GLBA Graham-Leach-Bliley Act. Part 2. Understanding Financial Privacy and Information Security. When analyzing a GLBA disclosure, the key question is, who is receiving the NPI? Under GLBA, non-public personal information, or NPI, may be shared with several different categories of recipients. The first category is affiliates. These are companies that operate under the same corporate umbrella, typically through common ownership or corporate control. For example, a bank may share information with another company within the same corporate family. The second category is non-affiliated third parties. These are individuals or organizations that are not related to the financial institution through common ownership or corporate control. Sharing NPI with these parties is generally subject to GLBA's privacy and opt-out requirements, unless an exception applies. The third category consists of exceptions where information may be disclosed under specific circumstances. These include service providers, joint marketing partners, government agencies, law enforcement, and regulators. Let's start with affiliates. Under GLBA, financial institutions may generally share NPI with their affiliates, but they must disclose these sharing practices in their privacy notice. Importantly, GLBA generally does not provide an opt-out right for affiliate sharing. However, other laws may apply. For example, the FCRA can restrict the sharing of certain information among affiliates. So, affiliate sharing is generally permitted under GLBA, but other legal restrictions must still be considered. Now let's look at non-affiliated third parties. Under GLBA, a financial institution generally may not disclose a consumer's NPI to a non-affiliated third party unless certain conditions are met. The institution must provide the required privacy notice, give the consumer an opportunity to opt out when required, or ensure that a statutory exception applies. For example, imagine a bank wants to share its customers' financial information with an independent marketing company to promote credit cards or other financial products. Because the marketing company is not an affiliate, the bank must determine whether GLBA permits that disclosure and whether the consumer must be given an opportunity to opt out. Other examples include independent vendors, business partners, and data analytics companies. GLBA provides 8 statutory exceptions that allow a financial institution to disclose NPI without triggering the usual notice and opt-out requirements. These include disclosures for business purposes, consumer authorization, fraud and security, professional advisors, law enforcement, consumer reporting, business transfers, and legal compliance. For example, a bank may share information with its attorney or auditor for professional services, or with law enforcement when legally required. We'll discuss each of these 8 exceptions in more detail on the next slides, including practical examples of when each exception applies. The key point is that these exceptions allow certain disclosures without giving the consumer an opt-out right. Remember, a customer is a type of consumer, specifically a consumer who has established a customer relationship with the financial institution. So, when GLBA refers to the individual whose information is being handled, it generally uses the broader term consumer. The first statutory exception that we are going to discuss is the business purpose exception. Under GLBA, a financial institution may disclose NPI when the disclosure is necessary to first, effect, second, administer, or third, enforce a transaction requested or authorized by the consumer. First, to effect a transaction. This means carrying out or completing a transaction requested by the consumer. For example, issuing a loan, opening an account, or transferring funds. Second, to administer a transaction. This involves servicing or maintaining a financial product after the transaction has been completed. This can include processing payments, servicing an account, or sending account statements. Third, to enforce a transaction. This involves protecting or enforcing the institution's contractual rights, for example, collecting an unpaid debt or enforcing the terms of a loan. For example, when a bank processes a consumer's credit card payment, it may need to share certain information with a payment processor. That disclosure can fall within the business purpose exception. Now we are going to talk about another statutory exception, which is the fraud prevention and security exception. This exception covers several purposes. First, protecting confidentiality and security. For example, a bank may share information with a cybersecurity company investigating suspicious activity or a potential data breach. Second, preventing fraud. For example, the bank may share account information with a fraud detection provider investigating suspicious credit card activity. Third, institutional risk control. This can include sharing information with an external auditor conducting a compliance or risk review. Fourth, resolving customer disputes. For example, transaction records may be shared with a payment processor to investigate a disputed charge. And fifth, disclosures to fiduciaries and legal representatives. For example, a financial institution may provide account information to an attorney acting under a valid power of attorney. The key point is that these disclosures are permitted because they serve important security, fraud prevention, risk management, or customer protection purposes. And as with the other statutory exceptions, disclosures covered by this exception do not give the consumer a GLBA opt-out right. Under GLBA, a financial institution may disclose NPI to professionals who are engaged by, or acting on behalf of, the financial institution to provide professional services. This can include attorneys, accountants, auditors, and certain oversight organizations. First, attorneys. For example, a bank may share customer loan documents with its outside counsel for legal advice on a regulatory compliance matter. Second, accountants. A bank may provide selected customer records to its external accounting firm for an annual financial audit. Third, auditors. An external auditor may review customer loan files to assess the accuracy of the bank's financial reporting and ensure compliance with applicable requirements. Finally, rating agencies. For example, a bank may share relevant financial information with a rating agency such as Moody's or S&P Global Ratings, so the agency can assess the bank's financial condition and assign a credit rating. Another important category is when a financial institution needs to comply with the law or respond to government authorities. There are several situations where this can happen. First, regulatory examinations. For example, an OCC examiner, the Office of the Comptroller of the Currency, may review customer loan files during a routine examination of a national bank. For those of you who doesn't know, the OCC is a federal agency that supervises and regulates national banks. Second, government investigations. For example, the FBI may request account records as part of a fraud investigation. Third, judicial processes. A bank may produce customer records in response to a valid court order or subpoena. And finally, compliance with other laws. For example, a bank may be required to report certain information under the Bank Secrecy Act or anti-money laundering laws. The takeaway here is simple. GLBA permits disclosures that are required or permitted by law. And because they fall within a statutory exception, the consumer does not have a GLBA opt-out right. There's another important concept to understand here: joint marketing. First, joint marketing is not one of the 8 statutory exceptions. It is a separate exception listed in the regulations implementing GLBA. The basic idea is that a financial institution may disclose NPI to another financial institution to jointly market financial products or services, without giving the consumer a GLBA opt-out right, as long as the required conditions are met. Importantly, this exception is limited to joint marketing of financial products or services only. It does not cover marketing in general. For example, a bank could partner with an insurance company to offer homeowners insurance to the bank's customers. Another example would be a bank partnering with a credit card company to offer co-branded credit cards. There are also important safeguards. The financial institution must provide the required initial privacy notice and enter into a joint marketing agreement that prohibits the partner from using or disclosing the information for any other purpose, unless it is permitted by another GLBA exception. And to wrap up, let's look at one final exception: authorization. Under GLBA, a financial institution may disclose NPI with the consent or at the direction of the consumer. Remember what we discussed earlier? Every customer is a consumer, but not every consumer is a customer. There are two situations to understand here. First, with the consumer's consent where the consumer agrees to the disclosure. For example, a customer connects their bank account to a personal finance app, such as Rocket Money or Monarch Money, and authorizes the bank to share financial activity data with the app, such as account balances, transactions, purchases, and spending information. Second, at the direction of the consumer. Here, the consumer actually instructs the bank to send their information to someone else. For example, the consumer may ask the bank to send their account records directly to their attorney. And that brings us to the end of our discussion of the GLBA disclosure exceptions. The key takeaway is that not every disclosure of NPI requires an opt-out. GLBA provides specific situations where information can be shared without giving the consumer that right.